we go to the third panelist, Alexander. He's a professor of international law and professor of economics at the University of Ostrava, Czech Republic, and chair of the Department of International Law and International Relations at Warsaw Management University. He has specialized in international arbitration, international law, private and public international, and reflection of human rights in international law. And I would like to add, I'm very impressed, he speaks a little bit in Icelandic. I don't know whether you're going to make your remarks in Icelandic, no? No. Let me finish with the title of your intervention. He's going to talk about right to access to the Secret Security Service archives in light of the European Convention on Human Rights. You have the floor, sir.
Tack för er, Madam Chair. But I'm sorry, I will not, in course of this of my speech, speak Icelandic. Even I do think that I do understand already sufficiently. But thank you for introducing me. Excellencies, ladies and gentlemen, also thank you very much for inviting me to this excellent event in respect to its consent, participants, as well as topic selected for this meeting, for this event. My topic to be spoken this day at that time, in this time, is the right to access to the Secret Security Service archives in light of the European Convention on Human Rights. It was certainly not for the first time the international initiatives and organizations employed with human rights and with protection of human rights were engaged in this issue, but it was for the first time in that extent and intensity, namely after the fall of the Iron Curtain, which means after the change of the political and economic situation in the former so-called socialist or communist countries, because the issue of surveillance of private entities, the storage and use of the collected information and their use for the future or notification to the citizens was was actually one of the first and very important topics the new regimes and new governments in those countries were engaged and were employed with as one of the very serious issues. The situation and the discussion on this issue in the post-communist countries also intensified the discussion on this topic on the international level and with international institutions, and brought this discussion as well as decision-making practice, like the decision-making practice of the European Court of Human Rights and the decision-making practice and the policy of another international organization, to completely qualitatively new level. It is not surprising that actually it was there were the Council of Europe initiatives employed and engaged as first on the international level with this topic in respect to the post-communist countries. Namely, it was first of all the resolution 1096 in respect to find transitional justice in post-communist countries. Namely, the paragraph 9 of the cited resolution 1096 said, the Assembly welcomes the opening of secret service files for public examination in some former communist totalitarian countries. It advises all countries concerned to enable the persons affected to examine upon their request to the files kept on them by the former secret services. As I already mentioned, and this is probably something I like to point out, the situation in the post-communist countries and the discussion on this topic opened there only intensified this issue on the international scene. It called for such questions like, for example, is the growing intensity of secret surveillance, collecting of persons-related data and their storage and processing really necessary for public safety purposes? And is this in accordance with the international instruments on protection of human rights? Of course, there are also another issues to be raised, but merely as a reminder, most probably not to be settled by purely legal instruments, like, for example, how far the intensification of secret surveillance only covers the inability of secret security and defense services. It is of the public power to meet their duties and tasks in respect to the public security, and mainly if reflecting which funds will be spent on and for those services. Since the past 30 years, the international organizations and mainly the more than 20 years, the international organizations and mainly the European Court of Human Rights were engaged in many cases and many claims with these issues. The protection of personal related details and the protection against secret surveillance, storage and usage of the collected data basis mainly on Article 8 of the European Convention on Human Rights, as well as on the Article 10. The Article 8, the respect to the rights of the one's private life, and the Article 10 as the regulation of freedom of expression. It is obvious that the practice of the European European Court of Human Rights merely tends systematically to base the protection on the regulation contained in the paragraph 8. Which means that the storing of information relating to an individual's private life and the use thereof and the refusal to allow an opportunity for it to be refuted amount to interference with the rights to respect for one's private life secured in Article 8, paragraph 1 of the European Convention, as it was expressed, for example, in the decision Leander versus Sweden, or in the decision Rotaru versus Romania. The paragraph 2 of the same article of the Article 8 set also for some exceptions, which means which means that the quality of law in question in respect to the protection of the one's private life, requiring that it should be that the law setting for such exception is accessible to the persons concerning and foreseeable as to its effect, as well as that it is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. In respect to the necessity of surveillance, which means to one of this exception, to apply for such exception, it needs to be adequate to protect the public interest. In particular, the surveillance measures and the proportionality was assessed as in the very first decision of the European Court of Human Rights in the case Class and others versus Germany. And the European Court of Human Rights expressed itself that these conditions, the conditions set in the Article 8, Paragraph 2 of the European Conventions must be interpreted narrowly. While acknowledging that intelligence services may legitimately exist in a democratic society, the court noted that powers of secret surveillance of citizens are tolerable under the Convention only insofar as strictly necessary for safeguarding the democratic institutions. Thus, despite recognizing certain discretion that the contracting states enjoy with regard to establishing the conditions of surveillance, the court maintains that the contracting states may not, in the name of the struggle against espionage and terrorism, adopt whatever measures they deem appropriate. At the same time, the fulfillment of the necessity in a democratic society requirement depends on the proportionality. Turning back to the main topic of my contribution, the necessity of such storage of information may appear doubtful, especially in circumstances where the information has been held by the authorities for a longer period of time. In that respect, may be mentioned, for example, the decision in the case Segerstedt-Wiberg and others versus Sweden, where alleged affiliation to some extreme left-wing political parties was related back 30 years ago. Even if such a storage exploring of such information for so a long time was identified as a violation of the basic rights for protection of one's private life. It was at the same time stating that in some issues and in some cases the access to such informations may jeopardize purpose of surveillance, which means that, for example, a refusal of full access to a national secret police register is necessary where the state may legitimately fear that the provision of such information may jeopardize the efficiency of secret surveillance system designed to protect national security and to combat terrorism. as it was stated in the case already cited, suggested Weiberg versus Sweden. On the other side, like it was decided in the case Weber and Saravia versus Germany, or again in the case Leander versus Sweden, or as well in the case Ekimtsiev versus Bulgaria. Also in such cases where the keeping of secrecy of such information and surveillance does not prevent the state and the secret services at least to notify to the particular private entities, private persons, that they have been or that there are even subject of secret surveillance. This was, for example, the case, the issue of the decision in the case Brinks versus Netherlands, Netherlands citizens subject of surveillance only because and due to their oft visits to Germany in the period of 1987 and 1990. I only hope, even if Iceland is a really democratic country, that I will not be subject of surveillance, because I do visit Iceland since 1988, really very often, or even a couple of times in a year. So I hope only so. Just a very last remark due to the limited time. There are also cases when the European Court of Human Rights based the protection in respect to the secret surveillance of private entities, private persons on the Article 10 European Convention of the Human Rights, which means on the protection of freedom of expression. The court found, for example, a violation of Article 10 of the European Convention in the cases Szabadság Jogokért versus Hungary, or Youth Initiative for Human Rights versus Serbia, when the court decided that the right to receive and impart information is a precondition of the freedom of expression, especially with regard to the matter of public interest. Mentioned due to the limited time, I don't like, and it was also not my intention to go into very detail. I mainly would like to remember the necessity of the discussion on this topic, which means protection of private life, protection due to the intensification of secret surveillance. Mainly because the secret surveillance, the collection of persons-related informations become or reached a completely qualitatively new level, as all of yours certainly can understand. And my last sentence would be a question. Of course, I don't expect any immediate answer, at least. If there is not the right time to open an international discussion on the new instrument for protection of human rights in that respect, because of the intensification of the surveillance worldwide and using completely new instrument and mechanisms. Thank you very much. Tack för er.